I have about 35 years of practice, exclusively criminal side. So the next date of hearing in the High Court is on 9th, and the next date of hearing in the Sessions Court is on 10th. So both the courts I am going to appear representing the complainant Kumari Najma. He says only Hindus can protect the nation, not the Muslims. He says Hindus are paying tax, not the Muslims. He says Muslims have many nations, Hindus have only one nation. These are all per se 153A inciting violence. Kalladka Prabhakar, he moved application under section 482 for quashing until quashing to stay. For the Honorable High Court, only notice was ordered, no order was passed by the Honorable High Court, but the government prosecutor, additional SPP, undertook that they will not precipitate the issue, in the sense they will not arrest him. So on the same day, accused Kalladka Prabhakar Bhat approached third additional session judge at Srirangapatna for interim anticipatory bail and consequently interim anticipatory bail, which was allowed on the same day, granting interim anticipatory bail. Now it is on interim anticipatory bail. So the next date of hearing in the High Court is on 9th, and the next date of hearing in the Sessions Court is on 10th. So both the courts I am going to appear representing the complainant Kumari Najma. See, I have about 35 years of practice, exclusively criminal side. He says only Hindus can protect the nation, not the Muslims. He says Hindus are paying tax, not the Muslims. He says Muslims have many nations, Hindus have only one nation. These are all per se 153A inciting violence, hate thinking, that is illegal case is rightly registered. It also attracts 295A and 505 subsection 2 of IPC. So therefore, when there is a prima facie case, see, High Court cannot appreciate the evidence, pros and cons, and what could be the cross-examination. It's a threshold prima facie case. According to me, there is a prima facie case. There are every chances that High Court may not accept the plea of the accused before the High Court. But as far as Sessions Court is concerned, the state has already finalized to file charge sheet. They filed an application before the Sessions Court that the investigation is almost completed. They are likely to file the charge sheet. It also indicates that the voice recorded in the hard disk and compact disk is already subjected to FSL for its opinion. That opinion is likely to come in favor of the state. Therefore, it is a straitjacket case. Then the question is whether he will get anticipatory bail. See, it is not an offence punishable with death or life imprisonment. It is at the most punishable with 5 years maximum. If it is brought under the purview of COCA or Terrorist Act, even then the punishment will not exceed 5 years. Therefore, since the punishment is not death or life imprisonment, there are every likelihood that the court may consider. So we will say that this custodial interrogation is important, therefore reject the bail petition. But the court may impose a condition that he would cooperate with the investigation. He should go whenever called for. Therefore, to that extent, our objection before the Sessions Court would be helpful for a straitjacket case to fix him with the offences mentioned in the FIR, for the offences for which the charge sheet is filed and the offences for which the charges are going to be framed. Anyway, there is a prima facie case. The court will definitely take this into consideration at the time of final verdict. I think the victim will get justice.
the 3 criminal laws passed recently in the parliament, will it be implemented?
Yes, it has to be. That's where the application presently filed is under 438. They should have filed an application under 482. The new procedure code 482. These type of offences, they could have filed charge sheet under section 111 and 113 of the Bharatiya Nyaya Sanhita. So that they have not filed. See, the application should have been filed not under CRPC but under Bharatiya Nagrika Suraksha Sanhita. They have not done it. I am going to raise this also, that the application is not maintainable. I am going to raise this on 10th. No, this already law is, this is the law of the land. Different courts are there, there are punishments also. Similarly, Arnab Goswami, he has faced, Supreme Court said, we will not quash the FIR. There are so many cases, there are so many precedents. It will, see, Rahul Gandhi, he spoke something at Kolar. He was convicted for 2 years in a Gujarat court. The High Court also upheld the conviction. Like that, this is 1,000 times serious than what Rahul Gandhi spoke. Let us see, we have hope on judiciary. Judiciary is ultimate. Yes. We trust judiciary, we trust it because country is smooth because of judiciary. And anything happens to anyone, it is only the judiciary which comes to rescue. There is no other forum, it's only judiciary. Judiciary is great, we trust judiciary.